First of all, House Bill 1201 is what I call the Campaign Finance and Ethics Reform Act of 2022. It's been a hard work over the past 15 months of citizens, legal advisors, and members of this body. First of all, I want to say the vast majority of members that I serve with follow the rules in regards to reporting campaign expenses and contributions. As I said before, since I've been up here, I've rediscovered a sense of purpose and camaraderie serving with these members that I have not felt since I was in the Army. And then the military is one of the highest regarded institutions of our government. Our intent here today is to increase public confidence and trust in the campaign process in regards to how campaigns are financed and how members are held accountable if they do not follow the law and the rules. Over the past year, we've discovered there are parts of the TCA that needs to change to ensure disclosure and to also to increase public trust in our election process. Chairman Williams and I have been working on this for over a year and a half, and I appreciate his help and support as we work through this legislation. And it's my understanding that Chairman Williams has an amendment that incorporates most of the amendments that I have presented last year in committee and have been working on with the members of the body. And with that, Mr. Chairman, I request my amendments be rode to the hill of this bill so we can hear the amendment that has been filed by Chairman Williams to see where we are in the posture of this legislation.
Good effort. But this bill, as it's rewritten and drafted now, in sections 1 through 5, I'm going to go through the sections of it, and it's happy to answer the questions members have. And if we get off into the legal weeds a little bit, I see the purple tide. Doug Himes is here to also help me ask questions. But sections 1 through 5 of this bill, it requires meeting agendas of the Registry of Election Finance of the Tennessee Ethics Commission and the Bureau of Ethics Commission and campaign finance to be published at least 5 business days in advance of meetings. As the members know, this is a requirement that we have to do for all of our local governments. This is just a similar requirement that we're going to request for these 3 entities, and it requires large registry and ethics commission civil penalties or those settlements to be approved in a public meeting. So currently, as long as they're in a public meeting, they can make settlements based upon those civil suits that are there. But if it's a large penalty, that they have to meet in order to do that. Section 6 of the bill, it removes the PAC blackout period, which was currently found unconstitutional by the courts. And so this just removes that PAC blackout period. Section 7 requires itemization of all expenditures reported on a long form. So in the 12 years that I've been here, I've never had one unitemized expense on here. As long as you use the long form, you cannot do unitemized. If you use the short form, you still can do an unitemized expense report. Sections 8 through 12, this is an enhanced interim reporting for candidates and PACs of contribution and contributions and expenditures received during the last 10 days of the election. So this would create another reporting report of those expenditures the last 10 days. As you know, vast majority of funds in elections are spent in those last 10 days, both in a primary and general election. This would require additional reporting for those. Section 13 extends the civil penalty joint liability to candidates controlling or serving as officers of PACs, and it prohibits PAC funds from being used to pay assessed penalties on those PACs. This is an important change. It requires treasurers and the candidate them both to be liable to those civil penalties, and you can't use your PAC contributions to pay for those civil penalties. You will have, if you break the rules and you are assessed a civil penalty, you will pay those fees personally in Section 13. Section 14 requires candidates and PACs to keep campaign funds separate and segregated accounts from other funds, including personal funds. This is not currently stipulated in the code. I did find out there are a few folks who still are commingling their personal resources with their campaign funds, and if this bill passes, then that will not be possible. Sections 15 through 19 revises the registry appointment provisions and requires provisions concerning restrictions on the service of registry and ethics commission members and their spouses. Section 20 imposes enhanced document retention on candidates for audit purposes and requests that audits be completed in odd number years. There was an instance where a member of this body, in fact, a member of this committee, there was a finding in the ethics for him that was unfounded, but it was during an election period, and so this would require the election of campaign finance to expediently make remedy to those accusations or those concerns so that it's not drug out over a long period of time. Section 21 adds members of the governor's cabinet to the list of persons who cannot receive compensation for consulting services. Currently, members of the cabinet can receive compensation for consulting. Section 12 is an enhanced disclosure on single sources of income of $5,000 or more and requires disclosure of member-controlled PACs. Some of the members have PACs that they have both a campaign and a PAC campaign. This requires additional disclosure. Section 23, and I'm more than two-thirds done, my apologies, clarifies that state trial court judges file annual statement of interest disclosures with the Ethics Commission. As you know, judges have a different ethics standard than we do, but this is just this was just an oversight, so we're adding judges as it relates to the statement of interest. Section 24 requires an annual statement of interest disclosed be signed under the penalty of perjury. Currently, it's not a penalty of perjury to sign those. Section 25 bans the use of pre-checked boxes as an authorization for future campaign contributions. So the members or PACs will not be able to send an index card in the mail with a return stamp in there that has the box or the monthly fee already checked for them. Someone will have to actually physically check the yes box. This means that the person is truly authorizing it and someone's not pre-authorizing it for them. Sections 26 through 29 deals with the advisory committee. It adds 2 members appointed by the advisory committee on open government to the Registry of Finance. The appointees must, quote, have a demonstrated nonpartisan interest in promoting government transparency and public accountability in the political process, which is, unquote, which is stated in the language of the bill. Section 30 requires any 501c4 that spends at least $5,000 for communications naming or showing the likeness of a candidate within 60 days of an election to be treated as a PAC for the purposes of filing an appointment of the treasurer form and reporting its expenditures. In Section 30 of the bill, it just gives the effective dates are varied for different sections of the bill, so to make it not cumbersome as it relates to those total elections. So that is the entirety of this Reform Act, as Colonel Whitson calls it. So I'm happy to answer any questions that the members might have.
Okay, we'll go ahead and start the list. Representative Shaw, you're recognized.
Thank you, Mr. Chairman. Back to, I think it was Section 25, talked about checking the box. I didn't quite understand that. Could you go over that one again, Mr. Chairman?
Chairman Williams.
Thank you, Chairman. Yes, anytime you're in politics, you have a tendency from your party wants to send you mail asking you to contribute to their campaign. I have received in my mailbox from candidates, all Republican. I haven't received one from you, Representative Shaw. Yeah, okay. But those boxes come and they have your name and address, and it says, do you want to do an annual membership, a lifetime membership, or whatever? And it already has the box checked in it. So all you have to do is sign. So what this does, it prohibits the check in the box being already printed on that submission. So thank you.
Let me recognize the sponsor. Representative Whitson, you're recognized.
Yes, thank you. Representative Shaw, exactly what he said. This keeps people from unsuspectedly allowing a campaign to take $10 out every month forever and ever and ever. It does not allow that. This is only for state elections only. Understand the federal government is also working on that to prevent abuse of particularly elders who do not understand. They want to make a contribution, they make a check on a box, and then the next thing you know, every month they head up for that fee, month after month after month, and we're stopping that.
Any other questions for the sponsor or the sponsor of the amendment? Leader Gant.
Thank you, Chairman. Under Section 22, can you define single source income?
Who's the question for? I'm sorry, Leader Gant.
The sponsor of the amendment.
Chairman Williams.
Thank you, Chairman. I'm flipping there to that section. So in section, I'm sorry, what section did you say it was again?
21. I'm sorry, 22.
Okay. Okay. Currently, when we do a statement of interest, when we do our statements of interest, which for the members, if you haven't done, it's due on Friday. The statement of interest going forward, which is why we have the alternate date, if you receive a single source of income that's more than $5,000, you'd have to report it on your statement of interest. So, for instance, if you have a consulting business outside of your insurance business and you receive more than $5,000 in that consulting business, you would have to put that on your statement of interest.
Leader Gant, follow up.
So somebody that's in, say, my profession, insurance, I receive commission statements from various insurance companies over $5,000. So I would have to list each company that I receive those commissions from on this statement.
Chairman Williams.
It's my understanding that you would have to do that, yes, sir. So if you work for X insurance company, I want to try to keep names out. If you work for X insurance company and you get a check from them, you're going to put that there. If you're writing insurance for 10 other insurance companies that you're writing policies for, those other 10, if all or any of those are you receive more than $5,000 from those entities, then it would have to be on the list.
Leader Gant.
So if that money comes in directly to me versus into an insurance firm, does that make it different?
Chairman Williams.
Yes, it does make it different. So if you're getting the check, if the check is being paid to your primary insurance and they write a check to you, you would not have to.
Follow up, Leader Gant.
And that would also pertain to any bonuses or any of that as well.
Chairman Williams.
Yes, sir.
Thank you.
Chairman Whitson, you're recognized.
Thank you, Chairman. Chairman Gant, what this basically does, say for instance, to answer your questions, as a result, under existing law, reporting officials who own businesses that provide services to clients in excess of $1,000 are permitted to simply report the name of the company they own as a source of income, rather than the actual names of those providing the income. So what this would do is, say I have a consulting company on the side. The real intent of this legislation is people who pay that consulting company, and I own that company through an LLC or whatever, I have to disclose those clients who spend more than $5,000, or that pays me more than $5,000 a year. Federal officials have to do that now, Secretary of Defense, Secretary of the Army, but also this is to make sure, and if you're a doctor, that's privileged, you don't have to report it. If you're a lawyer, that's privileged, you don't have to report it. It's just those sources of income over $5,000 that you have to report that you receive this. The real intent is to make sure members of our General Assembly, the governor's staff, commissioners, if they have a business on the side and they're doing business with clients that can influence legislation, they need to report that.
At this time, this makes me very nervous because I don't think very many of the chairmen have had this opportunity, but Speaker Sexton, you're recognized.
Thank you, Mr. Chairman. It's great to be here with you all today. I have a question for legal in this, because there's a lot of information out there about what this bill would do. And so I would like to have their interpretation on what this bill actually does and doesn't do. So to our legal expert on the committee, does this bill at all limit any 501c4 activities, prohibit any communication, prohibit them from doing any issue advocacy at any point throughout the year and during an election?
Without objection, we'll go out of session to hear from legal. Legal,
you.
you're recognized.
Thank you, Matt Mundy from Legal. Mr. Speaker, thanks for the question. This in no way prohibits, restricts, or limits the ability of a 501c4 or any other entity from engaging in speech, advertising, mailers, commercials, anything like that. There are, in my personal view, nothing that chills free speech when it comes to 501c4s. We only want them to report expenditures in excess of $5,000 that were made within 60 days of an election. Other than that, they can spend as much money as they want during a campaign, and they can say what they want during a campaign.
Speaker Sexton,
Thank you. Can we go back in session?
without objection, we'll go back into session.
And to the sponsor, so let me ask Chairman Williams about this. Is anything in this bill require the 501c4 to give out their contributors or their donors?
Chairman Williams.
Thank you, Mr. Speaker. As many of the body in this committee may know, last year I was able to carry a 501c bill or a 501 bill which preserved the privacy of 501cs as it related to their contributors. And this bill in no way prevents those contributors or requires that those contributors' names and information regarding them, regarding 501cs, be released. All it states that it allows a level, as legal said, it allows the same level of transparency to expenditures on those over $5,000 that this body and the upper chamber and PACs currently have to operate under.
Thank
Speaker
you.
Sexton.
Thank you, Mr. Chairman. And then to follow up on that, there's also misinformation put out that they would have to be treated like a PAC. Mm-hmm. But what this bill does is require them through the registry to list their expenditures only and not their contributions on any of those forms after they spend $5,000 within a 60-day window of a campaign. Is that accurate?
Chairman Williams.
Yes, Speaker, that is correct.
Thank you. Members, what this bill does in totality, it's all about transparency and it's about accountability. The voters of Tennessee, when you watch all different elections, they want more transparency in campaign finance. They want to know who's behind the money, how they're spending the money, because they're trying to influence the election. And issue advocacy groups can continue to do business just like they've always been. There's nothing in this bill that stops them from continuing to put out whatever they want. All this does is say if you spend over $5,000 within 60 days of a campaign, you got to report your expenditures and bring it from the dark into the light. And there may be some groups who don't like that. I could understand that because maybe they're not doing all positive stuff. Maybe they just want to do negative stuff. But what you do know is if you're trying to do something in a 60-day window in a campaign cycle, you're trying to influence somebody's vote. And the voters need to know, and the citizens of Tennessee need to know who those people are that are trying to influence their vote, just so that they know. Whether it's $5,000, people are getting hung up on $5,000. Imagine someone drops $1 million. This applies to everybody the same, all across the board. Doesn't matter if you're Republican, Democrat, conservative, liberal, nonpartisan, neutral. Every 501c4 is treated exactly the same in this bill. It also mirrors the federal on the last 10 days of a campaign, because what happens in the last 10 days of a campaign? There's not transparency. There could be contributions coming in. There could be expenditures coming in or going out. And so what this bill does is mirror what's going on at the federal level within the last 10 days of a campaign. Instead of hiding your expenditures or hiding these contributions and holding off and not being transparent, all this does is say, you can continue to receive those contributions. You can pay for those TV ads or whatever you want to do in the last 10 days. You just have to report it. This bill is nothing more than a mechanism to report and disclose, to provide transparency and accountability. And then the last thing is on the registry. All those people are politically appointed, either by the caucuses, by the governor, the two speakers, which is fine. But adding in two people from the open government side to be the watchdogs and the overseer gives us an added protection of making sure that that board's not political. Because if someone breaks the law, then they need to be held accountable. And the other thing that this bill does, if you do break the law and you're held accountable, why in the world would we allow them to use their political money that somebody gave them to do something political with to pay off those penalties for them breaking the law? So at the end of the day, what this really does is provide transparency and accountability on a lot of people. And unfortunately, sometimes you have to go through bad things to bring things to the light. And so what this bill is an attempt to do is not to harm anybody, but to allow Tennesseans to have a better understanding of how money's spent and making sure that anything in the dark now comes into the light. Thank you, Mr. Chairman.
Question has been called on the bill. Without objection, we're ready to vote on House Bill 1201 as amended. All in favor, please say aye.
Aye.
Opposed, no. Bill moves on to special calendar. No, I'm sorry. Finance. Moves on to finance.